Welcome to Case by Case. This is a podcast series brought to you by Luke Sadkovich and Calum Chain of Xylophloid Sadkovich. How are you today, Calum?
Very good, Luke. Very good. How are you?
I'm very well. Yeah, all good. All good. We're transitioning today, aren't we?
We're covering a lot of ground this series already. We've got some court decisions, we've got foreign law, and now we've got a London Arbitration Award.
Yeah, exactly. And last week's episode was all about Novak Djokovic. If you have not listened into that episode and you're just catching this one, it's obviously a completely different topic to what we're going to be talking about today, which is all about dunnage and vessels and cleaning ships up before redelivery. But it's worth a listen. And the update on that is that Rafael Nadal went on to win the Australian Open over the weekend, meaning that that court decision was potentially, one will never know, decisive in who was the first man to reach 21 Grand Slams.
21. Incredible. Totally incredible.
Yeah, did you catch the game?
I did. I watched I watched the first couple of sets, and then the third set, when he was down a break, I thought, okay, I'm going to go and have some breakfast now. And then took the dog for a walk, and then saw that we were into a fifth set. So hurried home, watched the fifth set, and I was just in awe of the ability of those guys to keep going after 5.5 hours. It's something else.
It's amazing, isn't it? He's an absolute fighter. And look, Medvedev, he was just run off his feet in the end, getting cramps and all the rest of it. But wow, what a game. It was amazing. So I think, yeah, very well deserved. Congratulations goes out to Nadal. And looking ahead to next week, I'm very excited. We've got our first external guest joining us, Mr. Adedoyin Afun from Bloomfield in Nigeria. He's going to be talking to us and with us about liens against vessels for wages paid to crew and whether that fits within maritime jurisdiction in Nigeria or whether it fits within employment jurisdiction. I wouldn't have thought it was up for debate, but in Nigeria, it most certainly is.
I was going to say we've gone international, but then I realized we've already gone international with Australian cases and American cases, but it's a fascinating conversation. It's a really interesting case with one of the preeminent maritime lawyers in Nigeria. Yeah, it was a really, really interesting conversation, and I can't wait to share that one.
Now, today, we're talking about dunnage and lashing materials for those of you who came into the podcast series listening to Novak Djokovic and have now come through to the next episode, you might be wondering what dunnage is. And of course, those that are in the maritime sector will know quite well. Look, the dunnage is the material that you put between items that are being loaded on it to keep them safe. And I think the analogy that I kind of use here is if you think about you're at the back of your car, about to go on a long road trip, and you've bought some precious gifts, I don't know, some vases or something that have to go in the back, and you decide to stick some sleeping bags in between them to make sure they don't break by the time you get to the other end. The sleeping bags, I suppose, would be the dunnage.
I was thinking of when you're getting the Eurostar back from Paris to London and you want to load up some nice bottles of wine in your backpack. So you take your socks and you put the wine in the socks so they don't clink against each other and smash. Then the socks act as dunnage between the wine bottles.
I like it. I like yours better than mine. Yeah, exactly. And look, on a ship, it's often wood or other material as well, depending on what's the actual cargo that's being loaded. And then lashing materials, that's the material that, as the word suggests, you lash down cargo, you secure it, whether it's ropes or other kind of pieces of whatever, to secure the items into place so they don't move around during transit.
And in this case, they'd left all of that on the main starboard deck, and when I say they, I'm talking about the charterers. So we have this situation where you have the owners of a vessel and they've chartered the vessel to the charterers, and the charterers therefore have the use of the vessel for a defined period. And at the end of it, they have to return the vessel into the owner's use. But there's often condition requirements about that transfer back to owners.
Yeah, exactly. And what we're examining today is a London Arbitration award. We've got a summary of that award. It's anonymous, so we don't know the parties involved, but it's given the reference number 522. So the recent arbitration, or at least in the sense it's been reported here, relatively recent, and we're working off a 2-page summary of it, so we don't have all the particular details, but we've certainly got enough to talk about today. I was thinking perhaps the place to start here, Calum, are on the obligations and what the charter party actually provided for.
Yeah, I think that's the right place to start, because there are two that are cited as being important provisions. The first is clause 4 of the charter party, and this is very standard across the New York Produce Forum, NYPE, and it says the charter shall pay for the use and hire of the vessel until the hour of the day of her redelivery in like good order and condition. And the second clause is one that had been added by the parties, and it was a new clause 50 called lieu of cleaning on redelivery, and it said charterer's option to redeliver the vessel with clean holds against payment of $4,500 lump sum, excluding dunnage, debris removal, disposal, which to be for charterer's time/account.
Yeah, and that second clause, while the exact words may differ here and there, and we might get into, in this case, whether the words mean anything special in this case, but it's a typical clause too, where charterers can redeliver the vessel with clean holds, and they're almost incentivized to do that by getting a payment, an agreed payment, a figure, a lump sum figure paid by the owners for those clean holds. And here there's a carve out for, as Calum says, dunnage, debris removal and disposal. It's not an entirely clear clause, but that's what we're dealing with. And this scenario is a really common scenario. So I thought it was a good one to select to talk through what happens when charterers do not deliver the vessel with clean holds, when they leave the dunnage and the lashing material on board the ship at the end of the charter party.
And the interesting point in this decision to me is all around the quantum, the question of quantum. And reading between the lines, it looked as though the charterers didn't deny that they'd left this dunnage on the starboard main deck, and that they should have moved it to, I think it was the cross deck at the final discharge port before they redelivered the vessel. So the question wasn't really, have you done anything wrong? The question was, what's the effect of that failure to comply with this clause 50? And what can owners charge charterers, or what's owners' recourse and damages for that failure?
Yeah, exactly. There wasn't any debate about whether the dunnage was left on board and whether charterers should have taken it off. They were responsible. Where the criticisms that charterers made, and I thought they were pretty weak criticisms, to be honest, was to say that after the vessel had redelivered and the vessel was then, so had gone back into owner's possession, say, it was then re-employed to subsequent charterers, so another company that had possession, use of the vessel, after the current charterers that we're dealing with. When those new subsequent charterers had the vessel on hire, that somehow the current charterers should have been allowed to go onto the vessel when it came back into the port for berthing to load for the next charter, that they have access to the vessel at that time to take off the dunnage. And had that happened, there wouldn't have really been a loss of time. It probably could have been largely removed without interfering with the loading operations. Well, that was charter's argument anyway. I thought that was a pretty weak argument, to be honest.
Yeah, it struck me as something which you'd need some pretty clear evidence that you would have been entitled to. You'd have to give clear evidence as charterers that your stevedores, the people who would be doing the cleaning up, would have been able to access the vessel while it was on charter to the new charterers to make that argument stick. And really, this is one of the difficulties with bringing up a mitigation argument, which is effectively what charterers were seeking to do. They were saying, we were in breach, but if you had taken reasonable steps, then you would have been able to mitigate the consequences of that breach and suffer no loss. But if you're trying to raise that kind of argument, then the burden is on you to show that the actions taken were unreasonable. And in this case, the owners the actions that they say were unreasonable were owners not just going headlong into the next charter party and saying to their new charterers, do you mind if, the old charterers, stevedores, come on board and clean up their mess? And they were never really going to pass that hurdle of saying that owners acted unreasonably in not doing that.
Yeah. And you're right to frame it as a mitigation question, because one of the principles in a mitigation context is that the non-breaching party, when they go to mitigate the damage or loss caused by the breaching party, they don't need to and are not obliged to look to the breaching party to help lower the cost. And if you think about it, I think that's entirely reasonable. That if you're been in the position of suffering a breach of contract against you, you can't really rely upon your counterparty who's in breach to then be involved in the mitigation effort. And if you don't involve them in that effort, somehow they can criticize you for not involving them in that mitigation effort, even if it may have achieved a lower amount. It's reasonable for the non-breaching party to look elsewhere. They have to try and mitigate, of course, but it's reasonable for them to look elsewhere.
Yeah, and we see this a lot in the context of a kind of mitigation offer made after a party breaches a contract. So if there's a contract between party A and party B, party A breaches the contract and party B is the innocent one. And then party A turns around and says to the innocent party B, I've just breached the agreement, but I can offer you pretty similar terms to the thing I just breached, but we'll just take out the clause I don't like. And they then fall back on the argument to say, well, you should have accepted that offer because you went out into the market and got something far worse than what I offered you, which was the same thing we were already agreeing on, just without the clause I didn't like. And there are a number of cases where the courts or tribunals have said you're not compelled to agree a mitigating offer. There is nuance to that though, and there are limits to it. You can't put yourself at serious financial disadvantage by just ignoring a mitigating offer. And if it is unreasonable for you to refuse it on financial grounds, then you could still have failed to mitigate. But generally, there's some leeway to say that the breaching party can't just hold the innocent party to enter into a new contract in mitigation.
Yeah, and I think reading between the lines of this summary of the award, I suspect there were arguments around how this claim was framed in the first place by owners. And this is straying onto quantum. But the first point to note on quantum is that the charter party rate that was in the charter that was breached was $9,000 a day. The next charter, so the subsequent one, the new one, was $6,000 a day. And so owners, understandably, were wanting to claim from the charterers the most that they could. So they wanted to frame their claim as a claim for additional hire and additional bunkers. So the bunkers, I think, were at a higher rate as well in the current charter and lower in the next one. So they wanted to claim for both hire and bunkers, almost as an extension of the current charter. And that's where you can see charterers' argument about, well, if you're kind of extending that charter and claiming on the basis that it just continues, then you should have really let us back on the ship to let our stevedores on to clear it off at a lower rate. So you can kind of see how charterers' argument in isolation looks a bit weird, but in the context of how the claim was framed, it makes a little bit more sense. I think the claim was framed wrongly.
Yeah.
It's a claim for damages for redelivering the ship in not good order and condition. But yeah, I think there's a little bit more to probably how this was pleaded out by the parties.
Yeah, I'm sure. I think that must be right. The charters were effectively saying, if you're trying to charge us the higher rate of hire that we were paying under our charter party, then we should be entitled, if your argument is effectively that our charter party was extended such that we had to pay this increased rate, then if our charter party was extended, we would have had access to the vessel. And therefore that should be factored in. And what the tribunal ultimately held, and I thought this was quite an instructive point from this award, is that the damages that owners suffered weren't the extension of the previous charter party. Instead it was a loss of entering into the next charter party. So the way that you assess the total quantity of loss isn't by saying, well, that previous charter party should have been an extra 4 days. It's instead by saying, well, you've cut out the first 4 days of the next charter party, and the next charter party was at a lower rate, so owner's claim was reduced accordingly.
Yeah, and on that point, I know that's how the award framed it, but I was thinking about whether that is the right kind of framing of the question, or whether I think the way that I would describe it leads to the same result. But it struck me that it was more a case of there, there's a breach on the redelivery of the vessel unclean. That's the breach. That's the date of the breach. You then need to look at what are the damages at that date, and that becomes a market measure. And the market measure is best represented by the charter that they managed to secure to continue on. But the way that they framed it here is different, and that is that it's delayed entering into this next charter. And so you look to that very charter for the loss under that charter, rather than thinking about it in an abstract damages sense and then saying, well, they've actually got a charter party that represents exactly what the loss would be at that point in time because it's already fixed. And so we're going to apply that as the market measure. So it's an interesting one, which in this case doesn't really matter one way or the other, but you can see where there's a gap perhaps in the charters that question might be more of an open one.
Yeah, I agree. And the other thing that crossed my mind is whether if the period of delay caused by removing all of this dunnage had led to a missed laycan, a missed cancelling date under the subsequent charter party, causing an entire loss of a fixture, then you get into interesting questions around whether or not that lost future fixture is the larger damages that come from losing a fixture as opposed to missing a few days of hire, whether those larger damages are claimable. And there's some interesting law around that. It's been a while since I looked it up in detail, but I think there's some obiter where I'm really kind of going off the top of my head here. I think there's some court of appeal obiter that says that if the party who is about to lose a fixture because of the breach notifies the other party of the potential to lose the fixture, then in certain circumstances, they may be able to recover the damages flowing from that lost fixture.
Yeah, but when? Sorry to interrupt you, but when does the notification happen?
Well, exactly. This is the problem with this obiter argument, because it happens. They would have to be notified. I mean, if you're looking at a longer term charter, for example, let's say you have a situation where there's just a straightforward late redelivery. If you have a 2-year charter party and the charterers redeliver an extra week after that, then obviously at the time of entering into the contract, there's no way that the owners are going to say, hey, in 2 years' time, we've got a really lucrative follow-on fixture. You've got to make sure you get the vessel back to us on time. So this is where this obiter comment for me kind of falls apart. I might try and dig out this reference and put it in the show notes to the judgment where they have these comments.
Yeah, the issue then is one of remoteness. Is the loss something which is too remote? And the point for considering whether the losses are too remote is what's in the contemplation of the parties when they're contracting. And obviously they're not contracting thinking about this future, potentially they're not contracting thinking about this potential lucrative fixture. So I think those arguments are pretty difficult to get through, but there's certainly something which people in the market can be a little bit concerned over. Some kind of unhelpful obiter can give you some pretty big concerns if your charter is looking at late redelivery.
Is there a causation question in there as well, though? Just thinking about it from the perspective of the charterers, someone had to clean this ship prior to the next charter. So whether it was done by charter, well, I suppose there'd be a redelivery date. So the charterers would have to do the cleaning and factor that in before the redelivery date. So if they're right up against the date and they breach the date, then I can see the subsequent laycan issue. But if there's no date in there, and let's assume charterers did do the cleaning within the charter period, then it's going to run longer, and that would be contemplated by the owners. I suppose it runs into redelivery notices and what are the obligations on charterers to give notices to the owners that they're redelivering.
Exactly. And what's the effect of missing those notices? If you have a 15-day redelivery notice that you're supposed to give and you don't give it, then are you still entitled to redeliver the vessel within the redelivery window? Or do you have to wait for a full 15-day period? And the answer to that is that you're in breach. But it's unlikely that you are required to wait for the full period.
Yeah. So here, what was the upshot?
Well, so here the upshot was that the losses were recoverable by the owners, but not at the previous charter party rate. They were recoverable at the new charter party rate. So they left with a good percentage of their claim. Let's have a look. About close to 60% of their claim plus costs.
Now, tell me, this might be a fanciful argument, but and I fully appreciate that it's an option. It's, in a way, charterers only get the benefit of the 4,500 lump sum if they exercise their option. But I was thinking, is there an argument for a recredit of the 4,500?
Interesting. To get the 4,500 back because they have essentially paid for the removal of the dunnage.
Yeah, so if they had cleaned it themselves, they would have got 4,500 out of it from the owners.
Yeah, so
the quantification of damages assumes a clean redelivery.
Exactly.
I think
a clean redelivery would have cost the owners 4,500.
Yeah.
There must be a reason that doesn't work, but that was something that jumped out at me.
You would have thought it would have been aired. Yeah, that's the very fair point, I think.
Anyway, we always look for kind of arguments that we would make that weren't made, and sometimes I'm sure they're
exactly.
If we looked at them in more detail and had the benefit of the whole claim, we think, oh no, that's not a good argument.
I wonder if the reason there is that there's the clean holds against payment of 4,500. And the dunnage is dealt with separately.
Yeah, I see that.
Could be that. Maybe someone will get in touch and say, this is one of their cases. We've had that before.
That's true. We have.
So if you're listening and you know the answer,
dial in, give us a call, send us a message.
Exactly.
We encourage all approaches and questions. And actually, we've had some questions come in from episodes that we recorded months ago. We've had some people asking us about demurrage and other things from some of the really early episodes that we've recorded. So look, we appreciate it all. Feel free to chime in. Let us know what you think of these episodes. If you've got some areas that you'd like us to focus on or an issue that you've been kicking around, we can probably look for a case to share with you and get into particular issues. We're open to those kind of things, but most importantly, thanks for listening in, giving us your time. We hope that you've taken something away from this. If you're in shipping and you're looking at redelivery obligations, this is a good one to start. And some of the principles that are in this, although this is about demurrage and cleaning the ships, some of the redelivery issues that we've touched on do run into other aspects as well of redelivery. Any final comments from you, Calum?
Nothing from me. Safe to say, if you enjoy the podcast, then subscribe, like, follow, whatever the button says.
Yeah, we'd be grateful. Thanks all. Until next time.
Cheers, everybody. Bye.